or was it done at the behest of another authority? So, the entire thing would have moved on that. Or also cases where a person was a lessee in respect of an existing plant, an effluent treatment plant, and he had to surrender the lease again. So the question is whether the compensation paid by him on surrender was in the nature of capital expenditure, or was it given mainly for the purpose of safeguarding himself against any likely pollution claims, because there was an effluent treatment plant out there. So the way in which you explain the case, the way in which you make it fit within the particular case law would make a big difference. I'm not saying that you should, state incorrect facts, but the way in which you emphasize certain facts and the way in which you make your entire presentation will make the difference. I don't think I need to dwell on this. I think more or less all this is pretty clear. And I think at the end of the day, one needs to be fair also when you're standing before the tribunal. I mean, if you know there's particular case of Supreme Court decision, if there's a decision against you, it's always better to point it out first that, Your Honor, there is a decision which is against me, but however, I would like to distinguish this on these facts, or these things were not considered. Rather than not point out that ruling at all, and then, then you can be assured that you'll be blackballed by the tribunal, because then every time you appear before the members, they'll, certainly they may not accept many statements that you may be making. I think Mehul will now take the balance part of the presentation. Thanks.
We are not getting any questions in between as I requested, so I hope we are with the flow, or it's maybe after lunch session, but do ask.
Yes.
My question is to Mr. Virin. You just said that you cannot go to the tribunal and say that this was not considered by the Supreme Court. My question is, can we really, when Supreme Court pronounces the law, can we really say that certain provisions were not considered or certain arguments were not put forward before the Supreme Court?
Certainly, in the sense that, if you recollect, there's a decision of the Supreme Court in the case of Sun Engineering, where the Supreme Court clearly stated that decision is an authority for only what it actually decides. So, in fact, there's a specific issue in the case of 234B, in the case of 115J. In the case of 115J, as to whether 234B would be applicable or not, the Supreme Court in the case of Quality Biscuits decided against, or rather in favor of the SSC. But again, when we decided the same issue in the context of 115JB, the Supreme Court in Rolta, Justice Kapadia referred to his earlier decision and said that no, in that case, the lordships, were not concerned. They did not recognize, this particular subsection 5 in section 115JB which was there, and they distinguished that. So, and apart from that, I think clearly, the issue regarding Vodafone, McDowell has been considered and distinguished in Vodafone. So there have been umpteen number of cases where eventually, everything depends on the facts of each case. So,
yes, I am completely agree as far as the distinction of facts are concerned. On facts, factual grounds, we can definitely distinguish. But when it is about the ratio that we are talking about, can we put forward such arguments that Supreme Court did not consider while deciding this ratio, or are you trying to say about obiter? Is your contention restricted to obiter, or is it also, are you trying to make it applicable even to the ratio?
No, I'm trying to say that when the Supreme Court or any other court decides an issue, that issue would depend to a large extent on the particular facts of the case and the legal provision. Now, assuming that there will be no changes in law, and then if the facts are the same, then as you have rightly said, that ideally, what is the point of distinction? No. It's only when there is some difference in the facts. As I said, for example, these are some of the rulings where, based on the peculiar facts, the Supreme Court itself, typically there will be so many instances of capital versus revenue. In a particular factual scenario, on a similar set of cases, the Supreme Court will decide this capital expenditure, or on a separate set they will decide that it's revenue expenditure. So one would really have to look at read the decisions carefully and see as to how they can be distinguished.
So what happens when the objections before DRP is filed in time, but before the AO is filed delayed by a day?
So I don't think because what we are filing with AO is just a same copy of that. So I don't think that should be very fatal to that saying that DRP itself is invalid. I don't think that would be correct. And that, as you said, just a one-day delay. So it's just a copy we are filing. Yeah.
Good afternoon, friends. Technically, my time is over before I have started. But I'll try making this as quick as possible. So, in the speed, if you are not able to understand something, please feel free to raise your hand, interrupt me at that moment itself. And we'll try making this as interactive as possible and as quick as possible. Okay, so now, Samir and Milind have talked about adjustments. Now, presuming that there is an adjustment for one of our clients, what are the alternative dispute resolution mechanisms that are available? And here we are talking about mutual agreement procedure and also advanced pricing agreements. You have been seeing in the press reports about advanced pricing agreements, etc. So, I have touched upon that. If time permits, I will also touch upon two issues which are very critical in transfer pricing and being faced by many taxpayers. They are in relation to management services as well as royalties and fees for technical services. But if time permits, I will touch upon it, or let's see how this phases out. Okay, so coming on to the mutual agreement procedure. Let me give you an example that there is a US multinational having a subsidiary here in India, and that subsidiary has been adjusted on account of transfer pricing. So now there is a risk of double taxation. So mutual agreement procedure can be opted for under the tax treaty. Basically, the double tax avoidance agreement gives the contracting states the power to opt for a mutual agreement procedure, power to the taxpayer. So once the AO passes the final order, so this gets activated only once the tax demand is crystallized. So the AO has to pass a final order. Post that, I can apply to the competent authorities for the purposes under the mutual agreement procedure. So presuming that there is a draft order by the AO and then there is a DRP proceeding which is pending, we cannot go to the mutual agreement procedure route because still there is no final order from the AO. So the process is that there is an Indian transfer pricing adjustment. So in our example, the application has to be moved to the US competent authority because US is a party which has been prejudiced by the stand that has been taken by Indian tax authorities. So procedurally it works that application is filed. There are procedural forms which are there in the US, and I'll just let you know what are the forms. So there is a covering letter wherein we are addressing it to the competent authority. There is a form 2848 in the US which you file with the competent authorities out there. And also there is a statement of penalty of perjury. Now this is almost akin to a declaration that whatever is stated in the application is true and certified by the management. What happens post that, once the filing is done in the US, a copy of that filing along with the covering letter here has to be filed with the competent authorities here in India. So post that, if they have any queries, etc., the competent authorities would consult the taxpayer. And I have given what is the distinction between MAP and appeal route, wherein some subtle differences are also mentioned of the MAP route. If let's take an example of a reverse scenario where there is an Indian multinational and that has suffered an adjustment in Japan or in US. What happens there? Then we have specifically Rule 44G, which talks about the Indian aggrieved party, where they can apply to the competent authority out here, and then a filing needs to be done to the US or the UK, wherever the subsidiary is. Now, in cases of US, UK and Denmark, we have actually a memorandum of understanding between the governments wherein there is a stay of demand on the tax that needs to be paid. So for that, the procedure is you need to have a bank guarantee in place, which also includes the interest till date. So interest till date means, now let us take an example of in 2014, if I am doing an application, I will have to estimate the amount of interest almost till 2016, presuming that 2 years is the time frame we are looking at initially. And post that we have to have a bank guarantee having the amount of interest plus tax, no penalties are included, and then furnish it to the authorities along with the prescribed form and our tax demand, and then give that set to the assessing officer, wherein this demand is stayed till the time of disposal of the MAP application. So, you know, we just discussed all this, so I'm just moving on to the next slide. This is the distinction that is there between MAP and the normal appeal route that we discussed some time back. So, the main distinction is that MAP is quick, vis-a-vis the appeal process, which actually takes around 7 to 12 years. Approach is more, it is more of negotiation and compromise rather than a legalistic approach or authoritative approach, which is generally followed by the appeal process or by the tax office. The taxpayer involvement is only till the time where first the application is filed, plus when they have queries etc., they would just approach the taxpayer for clarifications. That is it. Post that, what is the negotiation between the two tax authorities or the two competent authorities? The taxpayer is not made a part of that generally. So it is only between the competent authorities where the negotiations happen. Regarding the binding nature of the negotiation, say once the negotiation is completed, it is binding on the revenue. The taxpayer may accept it if it is fine with them, or they can actually reject the outcome if they feel that the outcome is detrimental to them. Simultaneously, the normal appeal process continues. So collection of taxes etc., we just mentioned about those points, and yes, it is binding on the revenue, we also discussed that. What happens now once there is a settlement done? What happens post? What happens to my existing appeal? So if it is favorable, then the group may withdraw all the domestic appeals for the period under consideration. Penalty proceedings are generally not a part of the MAP settlement as we discussed. So for that it is expected, but generally it is expected that the authorities may not press for them. If it is not favorable, I continue with my normal routine domestic process or for appeals etc. The cover of stay of demand obviously will no longer be applicable now. The tax demand will also include interest, and the penalty proceedings can be held in abeyance till the CIT appeal. What practically we have seen some instances where MAP settlements have been reached between US multinationals and Indian authorities. For example, say for IT enabled space, we have seen they settling at a markup of around 17 to 21%. So the range is different depending on the industry, but they have actually settled on some markups. No, for UK, I have not, in my experience now, but Samir, have you had any experience in UK?
UK? At least in UK? No, so I think in fact I was to just add and supplement on that point only that Varun mentioned US, India did settle some 2 years back, but somehow the relations between, I will not say political relations between India and US, but between the two competent authority of India and US were not very, how we put it, not very cordial or not very strong, and somehow there were differences. But it has again started moving since last 6 months, since India has a new competent authority, Mr. Akhilesh Ranjan, and he is very fair-minded. He was in Mumbai for many years in Aikar Bhavan and quite a fair officer. So that has started now, but UK and Japan, India is working very well, those MAP settlements, especially with Japan and UK. The settlements are reached very, very quickly. Japan, for example, one of our clients, we reach settlement up to almost March 9. Yeah, your March 10 just got over. Till March 9 the settlement were reached. So which is, as we discussed, is very quick, subject to, otherwise normally I would have been in TRP for March 9 or would have gone to tax tribunal. So at least for transfer pricing, I will, in appropriate cases, this is a good option. And the good part is, positive part is that you are continuing with our right of domestic appeal. We are not withdrawing that. And this is being resolved. And as a group level, there is no double taxation. So then you get a certainty. There is no further appeal by revenue to any other because it's accepted. And it has a strong case for persuasive value as Mehul mentioned. And we are just on EPA slide. So if the India's position is that if you are settling back, then I will settle IPA also for you quickly. So in a way, you are, and the practical it happens like for UK, Japan and US, they meet at least twice or thrice in a year. Japan CA may be coming in, I think, next 1 2 months to India, and UK was deferred now, they were to come in April or May. But so when they meet with number of cases, and each case has 2-3 years together. So you know, India's position is that if I am setting back for prior years where adjustments have been made, and if you are coming to APA for subsequent years, I can discuss both together because facts are same. You know, it's not normally facts are same. So this is a good mechanism which we must explore, especially for transfer pricing adjustment. Because and as we discussed at the beginning, the legal process in India is very time consuming, uncertainty, and with these cash flow issues, demand issues. So if you see on like to like, map can be more faster, though it's a tedious process and there is no guarantee that settlement will be reached, but then I am not worse off. I mean, here anyway I am waiting. So at least for significant cases we should certainly explore, and this will become a, I will say, a good resolution process at least for transfer pricing. There is no filing fee. There is no filing fee for MAP. So I just filed the application and they meet. And only thing we have to explain, and which we do formally, informally, they also call that you come and explain the case. My meeting is there scheduled with say USCA next 2 weeks, 3 weeks. Sometimes the calls are very urgent, come tomorrow, but then we have to do it. But that helps. So cost-wise, it's quite, I will say, cost time-wise, it's quite positive. Yeah.
So I think one important thing before we jump onto APA is the timeline for filing of a map. So it depends on the relevant treaty. Say for US it is 3 years from the date of the final AO's order, and for UK it is 6 years from the end of the financial year for which you are wanting to go for a map. So, and there are then local procedural requirements, like if say suppose for year ended March 2008, I wanted to file an appeal, or I wanted to file a MAP with the competent authority of UK, and say 31st March 2014 was the last day, then what happens, they also have a procedure that you can file a letter asking for that we are in the process and we will file a complete appeal or a complete document in due course, and by that we can actually extend the timeline also. So there are procedural aspects which need to be kept in mind. Coming over to APA, yes, the APA has been in the news for the past past week or so, because as on 31st of March, we just heard in the press that 5 APA applications have been finalized by the CBDT. So all those are unilateral APAs is what we know, and predominantly they have covered industries. For the first set, they have covered industries like pharmaceutical, telecom and financial services. APA was introduced here in India on 1st of July 2012, and first lot of applications, what we are talking about here, 146 applications, is as at 31st of March 2013. And we again had another one more year of filing of APA, where we hear that around 250 odd applications have been filed again. So that's almost 400 applications with the authorities. As Samir mentioned, that they have been relatively quick as compared to other authorities for disposal, because 5 APAs in 1 year is actually an achievement on the part of the APA team. for other countries, be it US or be it Japan and even China, we have been experiencing a time frame of around 2.5 years. So it is commendable on the part of the authorities. Basically, I think the main motto behind introduction was that India was being projected in the world as a very adversarial tax regime, and they wanted to have that taboo out. So that is the reason the authorities also have been very receptive when you approach them for an APA. Some of the areas where I would like that when you are representing your clients, we need to do much thorough work in an APA as compared to a normal transfer pricing study report. So you need to actually go into the nitty-gritties about the functional analysis, the comparables, whatever you are trying to put forth to the authorities. There is too much of work that is involved in an APA scheme. So please be mindful of these. Also, so just to give you an overview about what is the overall program, that it is between the taxpayer and the Indian revenue if it is a unilateral APA, or it will be between the competent authorities if it's a bilateral APA. It is binding on the taxpayer and the tax authority for the period covered under the transaction. APA will be cancelled if critical assumptions are violated. Now, you hear this, what are these critical assumptions? So critical assumptions generally, to name a few, it is client specific, but to name a few, generally they are that the functional analysis which has been presented to us, that is standard or that remains the same over a period of time, because APAs generally are negotiated for a maximum period till which they can be negotiated under the Indian law is 5 years. So the business of the taxpayer should broadly remain the same. There can be some minor changes which are not impacting the overall functional analysis that has been put forth to the authorities. Also, say some other assumptions like what will be the invoicing pattern, what will be the credit period that will be allowed. All this has to be a case-specific thing. It cannot be a generalized thing. So they have been actually negotiating based on our experience, because Deloitte also was instrumental in having one APA finalized out of the 5. So they have been actually negotiating on what will the credit period, whether based on the industry, whether 45-day credit period is fine, or 60-day credit period is fine, or a 90-day credit period is fine. So all these are finer aspects which need consideration. One of the main advantages of going for an APA is that they are much receptive to even other methods. Now, other method has been notified in the Indian regulations. Earlier, there were only 5 methods. There are some typical situations, complex situations where the normal 5 methods may not be applicable. Then these guys are much more receptive to having other method or having different type of analysis presented to them. They have the courage to look into it and also accept it. We talked about APAs being unilateral, bilateral and even multilateral. Multilateral is between many countries. In case anybody has doubt, please feel free to interrupt me. I am going a little quick. Bilateral APA is between 2 countries. Yes. So, wherein both the countries agree. So, when we are talking about the 5 APAs that were just concluded, they are unilateral APAs. Unilateral APA is between the taxpayer and the Indian government. Here it is between 2 countries.
So bilateral, if I want to same like math, sir. So India we have to file here, and our AE will file with their APO team or APO authority. So for example, continue Mayur's example in US. So they will file the APA application there as per their flow. And then both CA, like same way map, it's like extension of map is for past years, AP is for future years. So both CA will meet and discuss. Comparables. Not our CA.
Any bilateral this APA has been concluded?
Not yet. Maybe likely this year.
Generally takes around, generally takes around more time.
Both have to
2
meet.
years.
But I think likely to be this year. Should be next 6 months hopefully. That's all. Maybe we have to mention about the fees, because at KA there are fees.
Yes. So,
Including consultants fees.
so there are basic filing fees which are required, and that depends on the amount of transaction value. So say suppose if a client is applying for a 5-year time frame, you have to aggregate all the value of international transaction and then look at the slabs. Say up to 100 crores, from 100 to 500 crores, and from 500 crores and above. There are different slabs which are available and the fees which go to the Indian government.
How do you know the value today?
It is an estimation that you have to have based on your budgets. Now, there is a provision that suppose if you have estimated say 100 crores, my transaction value will not exceed 100 crores. But in effect, then when the transaction actually happens, it exceeds 100 crores. So it is in the next slab. Then there is a provision that you can file, you can pay the additional fee.
So minimum is 10 lakhs and it goes, maximum is 20 lakhs.
Yes.
And by Indian, I will say, our normally we are even tribunal fees is 10,000, I think maximum. 10,000. So it is very high for any standard. But I think they deliberated a lot, and to some extent that's why rules were delayed. I was told. Because provisions came in July, but rules came in September. Scheme. And one of the things Ministry of Law was objecting that why the fees are so high before they approved the rules. And I was told it was kept high so that at least some serious players comes into play. Otherwise, it should not be like, let's file it and see. Not that type of thing. So one of the reasons they kept it very high is relatively. Sorry, sir.
10 lakh when filing.
So 10 lakhs is up to 100 crores, and then 100 to 500 maybe 15 lakhs.
15 lakhs and
then over
500 crores it is 20 lakhs.
Yeah, what is the other thing?
The consultant.
Keloid fees would be how much?
Is somewhere we heard, no, it's facts and circumstances which case. But in fact, some taxpayers did allege we are arguing that if government fees is so high, I mean whichever is there, you have to see it that way. I mean there are efforts involved.
In the reverse scenario, if our estimation was high, your actual transaction value is lower.
No, that they were deliberately not given that proviso.
But sir, any unserious taxpayer will not go to authorities unnecessarily. They have kept 10 lakhs is a big piece.
Yeah, it is true, and as I said, lot of debate has taken place within ministry also.
Can you mention like any of the taxpayer unnecessarily go to authorities anyway?
No.
They do not like to see them.
No, what you say is very true, and as I said, lot of debate within ministry also taken place. When they propose fees, and I think Naresh was rightly saying, so subject to other countries also, India is very high. It is all as good as in US. But they thought because maybe TP disputes are so high, or they also done a lot of research on before like finalizing the slabs for this place. I was told a lot of
Means for small transaction, nobody will go for a
no, so I think what is they are thinking. I was told that like other countries, they also have a small and mid-size taxpayers. So I think once this is done and they will be settled down, I think I am sure there will be programs for this type of small size, which other countries also have, small and mid-size taxpayers. So I am sure they will. I think they are starting with, and he was not sure. I mean, the way Neuro saying 146 and 350. I mean, frankly, we met him on last Monday when this were APA Commissioner and India's Competition Authority when they were signing. Indian Competition Authority has signed on behalf of CBT because it's an agreement, as the name suggests, advance budget. It's an agreement between Government of India and the taxpayer. So they are also thinking that now they were not sure how much. I will say flow of application will come, but now 146, 250. Now, in fact, they are in a way concerned that if you take 146 or 150, 250, it's almost 400, and they will sign 5 now. So it's a big job for them.
What is the fees of bilateral APA?
That's same. It's what you have to see the other side also, because if US is there, you have to pay the respective country side. But India side, it's whether bilateral, bilateral, there is no.
I think there are slides, but I will not be able to cover it because of the lack of time. I will be happy to take any questions that you have in the tea break, because Naresh is very gentle on me, but he's saying that you'll just have 2-3 more minutes. But at the same time, any questions that you have, On the other slides also, I have given my card and the contact details are mentioned, so please feel free to check with me on that and I'll be happy to answer those.
Only Mehul, just to supplement, so Mehul has given, why don't you just